This is not legal advice. This is not financial advice. This is for educational and entertainment purposes only, and everything I say is my opinion. If you think the information I provide is good, please subscribe, hit the like button, and hit the notification bell so that you can get updates as I put them out. Okay, today we're discussing the separate but equal clause of the 14th Amendment. And what I did was I added an amendment to my lawsuit, and I said that the SEC laws violate the 14th Amendment of the Constitution, giving the hedge fund a distinct advantage, and therefore is unconstitutional. Now, my analysis is that the Jim Crow laws of the 19th century and the SEC laws kind of work exactly the same way. Because what the Jim Crow laws did, they gave a distinct advantage to one segment of society while marginalizing and disenfranchising another segment of society. The SEC laws, as far as I'm concerned, in my analysis of the SEC laws, it does the exact same thing that the Jim Crow laws did. It gives a distinct advantage to the hedge funds, the market makers, and the big dogs while marginalizing retail investors. Okay? In May of 1896, there was a Supreme Court case called Plessy v. Ferguson. And what Plessy v. Ferguson did was it legalized Jim Crow laws. It legalized local and state government laws that gave distinct advantages to one group while marginalizing another group. And anywhere you went in the United States, the states could do whatever they wanted with you with no legal recourse. It wasn't until May 17 of 1954 in Brown versus Board of Education, and in the Brown versus Board of Education case, they reversed Plessy v. Ferguson, and the Supreme Court held that the Equal Protection Clause of the 14th Amendment was applicable to all United States citizens. Okay? The purpose of Jim Crow laws were any state or local laws that enforce legalized marginalization of one group of society while giving distinct advantage to another group of society. Okay? Now, the Equal Protection Clause, and this is the definition of the Equal Protection Clause of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. When the SEC laws give the hedge funds, the market makers, the big dogs a distinct advantage where they're able to steal our money, they marginalize the retail investors. Those laws have to be held to be unconstitutional. These laws violate the Equal Protection Clause of the 14th Amendment. Okay? This clause was the basis of the Brown versus Board of Education, because what Brown versus Board of Education was saying was the law didn't apply to all the citizens equally. And the Supreme Court finally held that laws implemented by states, laws implemented by local governments had to protect all the citizens equally. The SEC laws do not do that. Okay? And some people might say, well, the 14th Amendment only applies to states, but the 14th Amendment doesn't only apply to states, because when the Equal Protection Clause itself only applies to states, while it does only apply to states and local governments. The Supreme Court held in the case of Boland v. Sharp in 1954 that a due process clause of the Fifth Amendment nonetheless imposes various equal protection requirements on the federal government via reverse incorporation. What that is saying is that even though the 14th Amendment applies to the states, the federal government is still required to protect our rights under the Equal Protection Clause of the 14th Amendment. Now, while the SEC technically is not the government, FINRA is technically not the government, DTCC is technically not the government, they are what we would legally consider government actors. So, as government actors, they are still obligated to follow the rules under the 14th Amendment of the United States Constitution. And when they implement laws that give the hedge funds, the market makers, a distinct advantage over the retail investors, they are violating the 14th Amendment clause of the U.S. Constitution, and therefore those laws should be considered unconstitutional. Until we all get together and abolish these unconstitutional SEC laws and force them to make laws that protect all citizens equally, that's the only way we can move ahead and have a fair and transparent market that protects everybody equally. Thank you very much. I appreciate everybody who looks at the video. If you have any questions, please leave them down. Click the subscribe button, click the comment button. Well, there's no comment button. Click comments, hit the notification button, and any questions you have, leave them and I will answer them. Thank you very much. Have a great day.